Hey folks, and welcome back to Conveyancing. This week we are having a look at subject matter of the sale, and I'll give you a quick introduction. And why is this buyer and seller looking so happy? Because they have properly addressed the subject matter of their conveyance, and hopefully that's what all your clients and yourself will also look like for every transaction, every conveyance that you do. You can see my little emojis, pretty happy about that. Four things we really need to get across today. Firstly, the identification of subject matter. That's not rocket science by any stretch, so we can get past that pretty quickly. Descriptions and misdescriptions take a little bit of discussing, so we'll have a little look at that. Defects in subject matter, and also lastly risk, and most importantly insurance. And I guess I can sum that one up for you in one sentence: always advise your client to get some insurance. But anyway, we'll talk a little bit more about that in just a minute. So looking first at identification of subject matter. Now, identification of the property will involve a decent description in the contract, and the description may also extend to plans attached to the contract. And then there is the issue of surveys and whether you need to get them, and whether the survey or the description in the contract will win the day. In terms of what the text says, it goes into a fairly detailed description about what's in the REIQ standard form contract in terms of describing the subject matter, and I actually thought it would be much easier to just take you to the contract so you can see it for yourself. So this is the relevant 2 pages from my purchase contract of my place that I bought in 2018. And you can see there, as I've got on the left there, the arrow with property details there. This is what we're obviously concerned with when we're talking about the subject matter of the sale. So property is one of the 3 P's that is essential in contract formation. You will remember property and parties and price, obviously. So subject matter is your property. You can see it contains there room for a street address. I've shown you that I do live in Runaway Bay, which is glorious on the Gold Coast. You can see the little box there, concise description of improvements, I think the text says. So you can see there's a little ticked box there, built on, so it's not vacant. It's lot 15 on a survey plan, and the survey plan has been set out there, and then there's the title reference number of the CT that applies to this certificate of title that applies to this particular lot. You can see the square meterage is also set out there, and it says land sold as, and it's ticked freehold. And you'll see the little rider there. If neither is ticked, the land is treated as being freehold. Uses residential, and everyone's signed off on that. And then on the second page, you'll see my local government, Gold Coast City Council. The text says it also includes provision for including any chattels that are part of the sale, which it certainly does. So all fixtures, fittings, and in my case, I get a dishwa, not a dishwasher. Provisions for price and so forth. But the other part on page 2 that I really needed you to see was down below where I've got the arrow there, matters affecting property. So this is where the encumbrances are generally referred to. Title encumbrances: is the property sold subject to any encumbrances? And it's ticked yes, listed in special condition number 8 of Annexure A. And there were quite a few encumbrances because, as you all know, my place is in a complex, and so there's easements running across the property for being able to access various different features of the property and common property. I bought it subject to a tenant being in there for the first 4 weeks, so we had to put in the tenant's name there. Obviously, a lease will be an encumbrance on the title, so that had to be set out there, and you'll see the amount of the tenancy, ending, the date that it ended, and the price and so forth. So that is the way that the REIQ standard form contract deals with setting out your property that's going to be purchased, so the subject matter of your sale. Then we need to look at the issue of plans, because plans will augment the description of the property. Usually a prudent buyer will go ahead and inspect the property. However, they're not really justified, are they? Well, a prudent buyer won't be justified just relying on what they see with their own little eyeballs. They will want to not only check out the description in the contract, they will want to see plans. Certainly a buyer cannot refuse an action for specific performance at the suit of a seller by arguing that they were mistaken about the extent of what they were buying because they simply didn't check the plans. Plans certainly, as I said, form a part of the description, so they augment the description of the land sold, and they have contractual force. In that respect, TEFBAU and Static Securities is the authority there. If you want a plan to operate as a warranty, that you will be assured of getting whatever it is that you see on the plan, then you're going to need to reference that in the contract itself, and the authority for that is Harris and Smith. Now, the last issue we need to touch on in terms of describing the subject matter of our purchase or sale is the issue of surveys, and you'll see I've got it smack bang in the middle there. The text says that surveys are an ordinary precaution. I would say that they're an ordinary precaution, certainly where your purchaser is only buying part of the land involved, or where there is commercial property involved, and that was certainly the case in Spinocio and McNamara there. You'll remember that was the case where the poor purchaser bought the Bull's Head Hotel, and there was a goodly proportion of it that was encroaching on other property. Certainly, surveys are important there, although in the run-of-the-mill houses and land contract that we might see that's subject to, for example, the REIQ standard form contract, surveys are not so much the ordinary precaution that perhaps case law might otherwise indicate. In terms of the standard contract, 7.5, as I say in the first bullet point there, 7.51 of the REIQ houses and land contract deals with surveys. As you can see there, first subpara, the buyer can survey the land, so there's your contractual right to enter and survey. If there's an error in the boundaries or area or encroachment or a mistake or omission in describing either the property or the seller's title to it, and any of that stuff is immaterial, or it's material but the buyer elects to go ahead and complete the contract, that is settle, the buyer's only remedy is going to be compensation, but you have to, as the buyer, claim that pre-settlement in writing. If, however, there is a material error, then 7.5 sub 4, as you can see there, the buyer can terminate pre-settlement. So that is the issue of surveys as dealt with in the standard form contract. Now, as I said, if there is a war of words and surveys, then it will be the survey that wins the day. As you can see, I've put down in red there at the bottom of the slide, if the description of lot 6 doesn't actually correspond with what's been pegged out, the subject matter of your contract is going to be the lot as pegged. So surveys, fairly heavy hitter in terms of description of the subject matter of your sale. So that is the issue of surveys, and that is the issue of identification. So now we can have a little look at description, or should I say misdescriptions in subject matter. Now, a misdescription is a want of title, not a defect in title. So that is the first important distinction to make. I think the text uses the example if the description of the subject matter was 1,000 square meters and in fact there was only 600 square meters, the seller may well have good title to all and every one of those 600 square meters. It's just that they are wanting in number. And so that's what we tend to say. A misdescription will be a want of title, not a defect in title. Now that does not mean that you're left without the remedy of being able to terminate. You certainly can terminate, and that will turn on whether or not there's been a material misdescription, which we'll get to in just a moment. But in terms of what constitutes a good old misdescription of the subject matter, then look no further than Jurema and Cato, which is the rather unfortunate case that establishes the fact that if there is to be a misdescription, an actionable misdescription, then that misdescription has to appear expressly on the face of the contract. You can't go ahead and try and apply a misdescription into the contract. And what happened here? Well, we had the sale of a 6-story office block at 140 Bundle Road, just up the road from me. Had a spacious car park, basement car park, that you could get to quite happily by pedestrian access. But unfortunately, there was no lawful access from the road to the car park. Inconvenient. What happened? The buyer completed the sale and sought compensation for a misdescription. How did they do that? Well, in the contract, clause 21.1b, as you can see on the slide there, gave the plaintiff the right to terminate if the access was other than by way of adjoining road dedicated for public use or by way of a registered easement to a road dedicated for public use. Now, that was not the case. And what the buyer's counsel tried to argue was, well, hang on a minute, if there's a right to terminate because there's no lawful access to the car park, then surely doesn't that mean that there's been a misdescription, because it would suggest that there is, or imply that there is, lawful access to the car park. Unfortunately for them, that's not the way that the court saw things, and as you can see there, they held that it doesn't follow that if access to the land was other than by such a road or easement, there was an error or misdescription. Had to be plain on the face of the contract itself. So that's the first thing to note. You have to have an actual a mistake, in the writing that appears on the face of the contract. How does the REIQ contract deal with misdescriptions? Well, let's have a little look here. And you'll see we're back at clause 7.5 of the REIQ, which we were just looking at before. And I did note for you then the significance, if you have a look at 7.5 sub 2 sub C, if there is a mistake or omission in describing either the property or the seller's title to it, which is immaterial or material, and they go ahead and complete, then your remedy is compensation. Otherwise, sub 4, if there's a material error, material misdescription, then termination is a possibility. We'll talk about material misdescription in just a moment. But 7.52 sub C is specifically designed to get around the decision in Trevinto nominees and Vlattis, and that was a 1970s case that involved interpretation of a phrase not unlike 7.5 sub 2 sub C, except it just didn't have the last few words in there, so a mistake or omission in describing the property. And in what was quite an unfortunate turn of events for the buyer there had been a lease. They had purchased the property subject to a lease. They were quite happy to do so. However, what was not disclosed was that there was an option for renewal contained in the lease. So obviously, if the lessee decided to exercise that option, they'd get a whole new turn, a new term of their lease, and then the buyer would be subject to that lease for the fresh term. They didn't particularly like that. They sought some compensation, and the dispute was around the phrase describing the property. Unfortunately, as I said, for the buyer, it was held by the High Court that the phrase describing the property did not actually extend to mistakes in describing the seller's title, and that's essentially what the failure to disclose the option for renewal of the lease was. It was a mistake in describing the seller's title, the seller's title being encumbered by that lease. So this is how we have the broader 7.5 sub 2 sub C nowadays. You can see that the provision is quite generous in terms of the definitions. So if you flip down, you'll see I've included the definition there from the standard contract of property. Property means not only the land, but also the improvements and any included chattels. So if there is a material misdescription in any of that stuff, then it will trigger off the remedies that are available. Now, this all begs the question, I suppose, what is a material misdescription which will trigger off the right to terminate? And that is the last thing we need to look at here in this little section. However, we are over that magical 15-minute mark, so I will end this video 1 here, and I will see you all in video 2. Bye for now, guys.